Our next witness is Robert Tembeckjian, the Administrator and Counsel to the New York State Commission on Judicial Conduct.
Thank you, Judge Cozier and members of the panel. I'll summarize the statement which I believe was distributed to you yesterday and certainly answer any apologies. I'm going to summarize the statement that I believe was submitted to you yesterday, and then I'll obviously answer whatever questions you might have. According to the American Bar Association, New York is the only state that has a multi-part attorney disciplinary system in the country. Similar to the way we disciplined judges prior to the advent of the Commission on Judicial Conduct in its present form back in 1978, where there were 5 different entities responsible for investigating judges. You've heard other speakers who have promoted the Commission as a model for you to consider recommending. It's the model on which the legislation for the Commission on Prosecutorial Misconduct is based. Let me just suggest that there are any number of ways in which the current multi-part system is disparate, not only in result, but in rule and in effect. In the first department, for example, a lawyer who is suspended for non-cooperation can be disbarred after 6 months without further proceedings. That's not so in any other department. In the first and second department, every time an attorney re-registers, he or she must certify to having read and abiding by the escrow rules, and those departments can conduct random audits of attorney finances. Third and fourth, not the case. The first and second appellate divisions have adopted separate rules for courtroom demeanor for attorneys, which the others have not. In the second, third, and fourth departments, one can be confidentially cautioned for misconduct that doesn't rise to the level of public discipline. In the first department, that is not the case. In the third, there is a very valuable letter of education, which the other departments do not have. We've heard from numerous speakers about the disparities in discipline that is imposed, not only for theft, but for others. Frankly, it is incomprehensible to me that an attorney who advertently steals funds of a client should not be disbarred. It should seem to me to be automatic. In the 35 years that the Commission on Judicial Conduct has been investigating judges for financial-related misconduct, there has never been an instance, or I should put it differently, any judge who has been found advertently, purposefully, to have misappropriated public funds has been removed or has resigned from office in a public fashion. It seems to me that underscoring and enhancing public confidence in the legal profession and the judiciary would require no less. The disparate system that we have in the various departments might very well have explanations and 4 different traditions that led to the disparities in the way the rules require the grievance committees to process complaints and the dispositions that are ultimately imposed. But while there may be explanations, there doesn't seem to me to be any discernible rationale for a 4-part system. But the solutions, I believe, are relatively simple, although they might require some political will. For example, you've got 8 different offices throughout the state handling disciplinary complaints against judges. I would not close a single one of them, but I would recommend imposing an overview, a statewide disciplinary council chosen by the Administrative Board of the Courts, which, appropriate to this task, is made up of the 4 presiding justices of the appellate divisions and the chief judge, to provide some continuity, coordination, and similarity in the way the grievance entities do their jobs. I would recommend the Administrative Board to put together a task force to recommend one set of rules, procedural rules, taking the best from all 4 departments into a common set of rules, which makes it much more logical, both for attorneys and their defenders in disciplinary proceedings, who practice across jurisdictions, to know what the basic rules of the game are, and they're not different. It makes no sense to treat a complaint differently because the lawyer committed the misconduct in Manhattan as opposed to Brooklyn, or Westchester as opposed to Buffalo or Albany. I would ask this task force to essentially start from scratch, write the best set of rules, substantively and procedurally as you may, taking the best of what there is, and to ensure a mechanism consistent with our administration of justice for there to be uniformity in result. I would propose that the Court of Appeals be given discretionary authority to review the discipline imposed or foregone by any of the appellate divisions. In the same way that the Court of Appeals will resolve different ways on substantive law and procedural law among the 4 departments where there might be disputes, it seems to me that the best way to say, for example, that any lawyer who stole money should be disbarred is for the state's highest court to say, that's what we would do and that is the standard, and to give them the discretion to take a suspension or a censure from the 1st or the 2nd or the 3rd department or the 4th department and say, we would do it differently, I think is a way of, under the due process of law, imposing some uniformity from where it ought to come, which is the state's highest court. I also believe that there is a lot that the current disciplinary structure can do presently to make its procedures and process more understandable and available to the public. If you look on the websites of the 4 departments, disciplinary committees, you will see a wide range and not an especially detailed, informative explanation, description, or history of what they do. Every single disciplinary complaint from whatever department should be on the website of that department. And there ought to be an index, as we have on the Judicial Conduct website, of substantive explanation or description of the kind of misconduct and a breakdown of the judge, the court, and the county so that it's relatively easy for us to determine, as I think Mr. Zauderer appropriately pointed out, the various clusters of behavior that is treated differently among the departments in a way that would make sense and inform the public. One reason why we can't answer the question about whether there is or isn't discipline of prosecutors is because even if there is, it's hard to find it. You have to search for keywords through Lexis or Nexus, and maybe you'll get lucky and hit a few. But it ought to be on the website of the disciplinary committees that are charged with making this information available and promoting to the public a greater understanding of how the process works. And to that effect, I would say there is a place for public disciplinary proceedings at a certain point. We have long recommended, and in New York it used to be the case until 1978, for the judiciary, as I would suggest, ought to be the case for attorneys. At the point that a duly constituted body, and that would be a grievance committee, has found probable cause that misconduct may have occurred and formal charges are preferred against the attorney, that's the point at which the proceedings ought to be made public. Not at the point of inception, not during investigation. I don't think we ought to be inhibiting people from making complaints. I think making complaints public at the point of inception would be unfair to the lawyer who is not going to be disciplined, and the vast majority would not, as is the case with judicial discipline. We get 1,800 complaints a year. We investigate about 200 of those. About 20 judges at most are going to be publicly disciplined, and we might have 30 or 35 cautions. The same percentages are very likely true among the bar, but when a formal body of sophisticated attorneys has made a finding or a probable cause determination that there is misconduct, that ought to be public, because the license to practice law is not just a privilege, it's a public trust. And I believe that the public has a right to know when a grievance entity has decided beyond the investigative stage to formally institute charges. And I would say that there's a lot that could currently be done to expedite proceedings. For example, the judicial disciplinary system has an instrument called the agreed statement of facts, where the judge and I, as the person representing the commission in the equivalence of the prosecutor, may very well agree without a hearing that would take up time and great expense both to the state and to the respondent, that there is no dispute as to the facts, where In many of our cases, the judge is acknowledging having engaged in misconduct and will stipulate to it, and the Commission on Judicial Conduct has the opportunity and the authority either to accept it or reject it in toto. If they reject it, it goes to a hearing before a referee. If they accept it, we have saved 9 to 12 months of time and expense, and the public is informed at a much earlier stage as to what the appropriate discipline is, because by delaying the proceedings and without properly and adequately funding the disciplinary process, and I think that is also an issue that you've got to look at, because over the last 10 years, the overall funding has declined in terms of staff presently doing the job of disciplining lawyers.
Mr. Tembeckjian, your time is just about up.
Okay, I'm just going to wrap up with one thought in this regard. A process that takes too long is unfair to the public and to the lawyer. No lawyer, and no judge for that matter, should be under the anxiety, the stress, and the opprobrium of having charges hanging over them that are ultimately going to be dismissed. And the public should not have to wait an undue period of time for the lawyer or the judge who is engaged in misconduct to be appropriately punished for that behavior. So it seems to me that opening up the process at an appropriate point, using some of the tools that are available now to make the process more explainable and understandable and accessible to the public, and layering some of these other procedural changes through the administrative board of the courts is, in my view, compelling.
Thank you. Yes, Professor Killers.
Thank you for that. Let me pose a question from the outfield that draws on your experience in professional discipline. It seems to me
the outfield is usually where I feel I am, in the gathering of lawyers and judges.
It seems to me that any disciplinary system has limited utility in protecting the public. First of all, it's after the fact.
Correct.
Right? It's not before the fact. So something bad's happened already. And even the best system is going to be imperfect. We should try to be as good as we can, but there's a limit to what a post hoc system can do. Now, what that suggests is that the best way for a prospective client to protect himself or herself is to choose the right lawyer at the outset. And the way people have traditionally done that, or should do that, as with other professionals, is through word of mouth, talking to friends and acquaintances about their experience with Lawyer Smith or Dr. Jones. Now, it seems to me in an internet age, exchanging that kind of information about lawyers should be much easier. And so what I'm asking you is, do you see any way of creating the functional equivalent of a TripAdvisor for lawyers? You can look up the hotel, you can look up the restaurant, you can look up many businesses that provide services. If exchange of information among other consumers is really, in the end, the best way to protect yourself as a consumer of legal services, should not we make it easier for prospective clients to hear about the experience of others through an exchange of internet information?
Well, that's the kind of recommendation I might make in a second career after I have retired from the practice of law. I do think there is some merit to it, but I'm not sure that that's the role of the state or the grievance committees to provide the Yelp-like review. I don't think there's anything that we could do to stop it. Frankly, Professor, having heard you make the suggestion, I'm surprised it hasn't happened already in the internet marketplace. There are certain things that I think that the grievance structure can do, and I've hoped to have outlined some of those. The most effective and simplest of which is to put every public discipline of an attorney that they have rendered on the website, so that people have access, at least to those who have been adjudicated to have engaged in misconduct. I'm not sure to the degree that I would trust a system of Yelp-like ratings of attorneys, which can be skewed both positively by the attorney and his or her friends, or negatively by the one person out of 1,000 who might have had a bad experience with that particular attorney. I think it's worth study, and it's intriguing. I'm not prepared at this moment to recommend it, though.
I know that your long-time professional work deals with judges, not lawyers who are non-judges, but let me draw on your experience and tangle with you a little bit on something here.
Sure.
Do you think, now let's not talk about for a moment the very obvious severe offenses such as taking escrow funds and stealing and those very serious offenses, but things that are the meat and potatoes of disciplinary committees like conflict of interest, right? A lawyer is disqualified in a case because acted in an arguable situation adverse to a client's interest. Now, there could be big regional differences and cultural differences, large firms versus small firms. The federal and state courts have different approaches to walling off lawyers, for example, where a lawyer represented a client and now comes to a firm which is adverse to that client. And those really are because of different outlooks and cultural differences. You know, the environment which a lawyer practices in Glens Falls, who misses a court date, maybe because her car broke down, you know, may be different than someone who practices in New York City in a large firm where there are resources to deal with it. So isn't there a value in keeping local knowledge a relevant factor, having 4 disciplinary committees who know the people, and I don't mean in an intimate way that would preclude them from judging a case, but know the culture, know the practice, when they hear the testimony, just as local juries are called upon to hear testimony knowing the community, maybe not friendly with the particular defendant. Isn't there a value in that we should respect?
Well, I think that there is, and I think that whether it is a statewide application or a regional application, any entity of responsible people can make reasonable determinations as to what's appropriate and what's not, and what ought to be publicly or privately disciplined. And I'll give you an example from my own experience. In a sparse county, single judge county, upstate, where within walking distance of the courthouse there may be 1 or 2 places to have lunch. It's not uncommon for us to get a complaint that might say the judge was eating with the jury in the local diner and shouldn't have. And on an investigation of the facts, we determine there's only 1 or 2 places you can go. And no, the judge wasn't sitting down with the jury, but they happened to be in the same restaurant at the same time. That's not going to result in discipline, because a reasonable application of the rules to those facts, and I would say that might be true in Brooklyn as it might be in Franklin County.
Yeah, but a statewide body might not be in the same position to evaluate and understand that as an appellate division or 4 different bodies.
Well, that's right, but I'm not proposing a statewide body. I'm proposing a statewide coordinated disciplinary committee system that would still put before its recommendations to the appellate divisions, but, and it's not an authority I would expect it to grant very often, or to exercise often, to have the Court of Appeals with the discretion to review what an appellate division has done in discipline, to determine whether or not they got it right or wrong. I'm not promoting at all supplanting the appellate divisions. I would think 99.9% of the decisions would still be rendered by the appellate divisions. But in that rare occasion where the Court of Appeals might disagree and doesn't have a mechanism to do so now, I think as the state's highest court and the ultimate authority for ensuring public confidence in the rules and the administration of justice, they ought to. Hi, nice to see you again. Which I should say is only because you were a witness in one of my proceedings many years ago, in which the judge waived confidentiality, by the way, one of those very few.
So, Mr. Tembeckjian, before you mentioned the question of the letter of education, and you cited to one of the departments, I forget which.
That's right.
Okay, but in the second department, we had the letter of admonition. How is that different? I'm not familiar with the term letter of education. So how is the letter of admonition different from the letter of education?
I believe an admonition is a discipline that can be, that the respondent has the ability to challenge, but it's a discipline as opposed to a confidential suggestion or recommendation, which is not disciplinary.
We also have the letter of caution, which is in the hierarchy,
Right,
which is below the letter of admonition.
Right, which you do, but the First Department does not. What I like about the letter of education is that its title essentially describes it. So if you get a letter of education, I think you know what you've gotten. You haven't been punished, but you have been advised on a way to amend your behavior to avoid problems in the future. Whatever we call them.
We change the title of the letter of caution to a letter of education.
Well, the Third Department has a caution and a letter of education. And the point I'm trying to suggest is that there's no reason for there to be 4 different sets of nomenclature among the departments. Everybody should have a caution. Everybody should have an admonition. Everybody should have a letter of education, as well as the public disciplines.
Mr. Morton?
Thank you. I'd like to get back to something that my colleague, Mr. Gardner, was talking about, and it's on the statewide system. And thank you for your testimony. You bring a unique perspective overseeing a body like you do. Just to be clear, you're not suggesting that we should recommend blowing up the existing system and creating a whole new commission on attorney conduct, for lack of it.
I would agree. I think that the current system fundamentally is sound, but that it is so confusing and somewhat disparate in its various approaches that an overall uniformity in the way proceedings are brought and cases are investigated among the departments would make, I believe, a greater uniformity by the appellate divisions in rendering decisions more likely. Same set of rules, same set of substantive requirements, and uniformity in the way that they are prosecuted.
Just to follow up, I think harmonization of the various appellate division rules is something that this commission is looking into very seriously. But you also suggested a discretionary review by the Court of Appeals.
Right.
That would essentially give the Court of Appeals a factual review power in the disciplinary context. Do you think that would require a constitutional amendment to accomplish that, or would that be merely statutory?
Well, I'm not sure. I think any conferring of new jurisdiction on the Court of Appeals, I think, would have to be constitutional. Whether we began by giving them essentially administrative review authority, which would be, similar to the way it might review decisions of an administrative agency or an Article 78, is possible. Likely a constitutional amendment if this is viewed as conferring new authority on the court. In commission disciplinary cases, it is constitutional because the court does have de novo review power, and there are occasions where they may disagree with the facts as found by the commission, although typically in the vast number of cases, and we've had nearly 100 reviews in 35 years by the Court of Appeals, the facts have been accepted, and it was the ultimate discipline on which the court may have disagreed with the commission. I think in about 75 to 78% of our cases, they agreed with both the facts and the discipline, and in the rest, they agreed with the facts but disagreed with the discipline, sometimes raising it, sometimes reducing it. I wouldn't be afraid of recommending a constitutional amendment because I do think ultimately putting the Court of Appeals on top of the system where it belongs is the appropriate way to go. Again, I don't think they would exercise that authority very often, but where necessary, they should.
Thank you very much, Mr. Tembeckjian.
Nice to see you.